Good morning. It is March the 3rd, and I am so excited for us to get started. This is good stuff. We have made it to March. We are almost there. You should be able to see the end of the tunnel, or at least you should be able to see the light. So, this is where we're going to start. I am going to repost this PowerPoint because I've added to it. We weren't able, we had good energy going, we had good participation going, we had a good rhythm going on Monday. We were able to look at some sample questions, we were able to go through the answers together, and that was amazing. The issue is we weren't able to finish it. Initially, I thought, well, the PowerPoint's already posted. And so what I'll do is just encourage them to finish the PowerPoint on their own. However, I had over 30 PowerPoints, and I think we didn't get halfway through. And in speaking to those of you that I spoke to after class, I realized the best practice would be for us to finish this PowerPoint together. And so that's why I have the video. That's why I'm going to post the video with the new PowerPoint. And that's why I'm going to take my time. Uh, 45 minutes is just not enough time for us to warm up, for us to jump in, for us to really get some of the work done, and then for us to cool off. So by posting, I believe that we can do an adequate and appropriate review of what we've already discussed to make sure that you understand. And if there's a piece that you don't understand, hopefully by slowing down, we'll be able to identify exactly what it is that you don't understand. So that way we can provide clarity, right? We can fill in the gaps. But in order to fill in the gaps, we have to know where the gaps are. So, first, I want to say to you, congratulations for finishing your formative. I know, I believe in my heart that you've all done well. And so we're going to put that behind us and we're going to continue to move forward because we can't make progress and then stop and lament, right? We've got to make progress and then continue to move. So, what's going to be due Monday, March 6th, 2023? Yes, we will meet in person. Yes, we will be in class. What is going to be the work product that I'm expecting to receive from all of you at the beginning of class? At the beginning of class, slow down, get prepared, make sure that you have everything that you need with you when you leave. At the beginning of class, my expectation is that you will come in, you will find your folder, you will place the Osborne, the Irwin Memorial Blood Bank brief in your folder. Second, I expect for you to take the other set of folders. Yes, two sets of folders. One set will have nothing in it. That's where you're going to start placing your new briefs, not in a pile, but in your folder. Second set of folders are going to have the briefs that I've graded and that I'm returning to you. You can actually pull that folder out and take it with you so that when you turn briefs in on Wednesday, I'm going to be giving you a folder, one that has been graded. You're going to be giving me a folder. So now we have a two-folder system. I'm trying to figure out how to prevent the melee and the chaos of can't find my folder, can't find my folder, can't find my folder when they've all started in alphabetical order. Two-folder system. Come in on Monday, find the set of folders that are empty. I'll actually write on the folders. These folders are empty. You will then place your Osborne brief in the empty folders, and then you will take the folder from the other set that says return folders, which will, and take the whole folder so that you have a folder to tender your briefs on Wednesday. Got it? What's due on Monday, March 6th? Osborne, the Irwin Memorial Blood Bank. We are going to begin our module on professional standards. Keeping it moving. Let's go back to the land of vicarious liability. There's only two ways that we're going to cover about vicarious liability. That's going to be respondeat superior, which is, or respondeat superior, or respondeat superior, or however you choose to pronounce it. But the first area of vicarious liability that we're going to cover is respondeat superior. But it's not the only category of vicarious liability that we will cover. The other category of various liability that we will cover is the second category, is motor vehicles. Okay, keep moving. Vicarious liability, you already understand this. Legal rule holds a person or company responsible for the actions committed by another. We got it. We know what it is. Don't need to belabor it. Categories, respondeat superior, and which is the vicarious liability for employers. Second category is vicarious liability as it relates to owners of motor vehicles. We're going to do a real quick review of what we already reviewed just on Monday. Explained. Respondeat superior is a legal doctrine that holds an employer or a principal legally responsible for the wrongful acts of an employee. Got it? We talked about it. We know it. We already did the case. Yeah. Respondeat superior addresses the tortious act portion of the negligence equation. Say what? The negligence equation has four elements: duty, breach of duty, causation, damages. Where does the respondeat superior fall in that category? Respondeat superior falls within the tortious act portion of the equation, and the tortious act portion of the equation is the duty and the breach of duty. Okay, take a minute, slow down. I'm going to do a comparison. You're in criminal law. In order for a alleged defendant to be found liable, you have to establish mens rea and actus reus. Those are the acting parts of the equation. Once you've established the mens rea and the actus reus, you look at causation, because there's got to be a link, right? Got it? Same formula for negligence. You have to establish the act. There has to be an act or omission, all right? Very much like criminal law. But the act is the duty and the breach of duty. Once you've established those two pieces, then you go to the causation piece, then you go to the damages piece, right? All right, moving on. Let's see, trying to make my little PowerPoint move along. And for some reason, there we go. We talked about this on Monday. How do you determine if an employee is acting within the scope or incidental to their employment, right? Because that's the only way that I can get an employer to be liable for the actions of the employee. I have to show that the tortious act, right, the duty and the breach that resulted in the harm or the injury or the accident, whatever the thing is, I have to be able to establish that that was being done while the employee was acting within the scope or incidental to the scope of their employment. There's two tests: the benefits test, we talked about it on Monday. Here it is. The characteristics test, talked about it on Monday. Here it is. I hesitate because, again, after class on Monday, I had students coming to talk to me about strict liability. If I give you a negligence question, if it is a question about respondeat superior, do not, please do not, please do not use the term strict liability. Then why do I put it in here? Because if you haven't figured this out, I try to draw analogies, comparative analogies, to help you relate to what we're talking about, right? If I can relate something new to something that you're already familiar with, adult learning theory tells me that you've got a better probability of actually incorporating the new language, better opportunity to digest the new language, and you're more likely to use the new information that's been introduced. That's why I try to draw upon analogies. This comparison to strict liability was simply an analogy. That's it. It's just an analogy. And it was an analogy because it's important for you to understand that under the terms of respondeat superior, if you are my employee, if you are acting within the scope or incidental to the scope of your employment with me, if you act negligently, if you injure someone as a result of the negligence, I, the employer, cannot, say it again, I, the employer, cannot, one more time, I, the employer, cannot escape liability by saying, I did not intend for you to act negligently. The fact is that you did it. I'm guilty. I cannot escape liability by saying, I have a policy that the employee is not supposed to do that. Doesn't matter if the employee did it, I'm stuck. I can't say, well, everybody knows, it's common knowledge that you're not supposed to do this thing because it can injure someone else. I cannot escape liability. It acts as strict liability, meaning doesn't mean what my intentions may be, doesn't mean what my intentions as an employer were, doesn't mean what my intentions as an employer are as they are related to future events. Nobody cares about my intent or my lack of intent to have an employee act negligently, right? If the employee did it and it was done within the scope or incidental to, and it caused an injury, I pay for it. That's all I mean. It's just an analogy. Exceptions. When can an employer raise an exception? Not a defense, but an exception, so as to escape liability. Frolic and detour still makes me feel like somebody in, spring clothes with spring colors running through this beautiful, I lived a large part of my life in Austin, Texas, practiced majority of my practice in Austin, Texas. And so we have bluebonnets, right? Every spring, they're everywhere. People pulling over on the side of the road, taking pictures of the bluebonnets. So when I think about frolic and detour, I think about people running through the bluebonnets. But anyway, all right. Detour. We talked about it on Monday. Detour is a minor departure. What does minor mean? Depends on the facts. Depends on the facts. Minor, right? I'm out, I'm making some deliveries because that's my job. I'm in between deliveries and I go to the snack and run gonna grab a biscuit and sausage to go. I bump into another car in the driveway and I injure them. Don't know how fast I was driving in the drive through, but I was driving fast enough in the drive through that if I bump into the back of somebody, I hit them. Can they sue my employer? Probably. That was just a detour. I wasn't on lunch. I wasn't on break. I'm in between deliveries. I see the snack and run, and I'm just going to take a detour. Let me just detour over here, grab something real quick, and get back on my route, right? Detour. That is a minor departure. A minor departure means I'm still handling the business of my master. I am still handling the business of my employer. If I get into a negligent situation and injure someone, and it's my negligence that injured them, on a detour, my boss is going to pay that check. Okay. Frolic. Look for two things in the fact pattern. Frolic. Look for break, like I'm on my lunch break, right? Or I'm on a employee break. A lunch break, from this perspective, is intended to be for the benefit of the employee. Your belly's hungry, you feed your belly. That benefits you. Okay. Law says 8-hour shift. I've got to give you two 15-minute breaks. You need to break away from anything that you're doing for me, the employer. You need to break away from my protection over your actions. You need to break away so that you can have some time for yourself. A lunch break, a break. Those are considered major departures. Think about the word break, B-R-E-A-K. I'm breaking, right? Breaking. Or you can say I'm using my B-R-A-K-E, break, to B-R-E-A-K. However you want to do it, right? But a frolic is considered a break. And the two accepted frolics are lunch break and an employee break. Got it? Moving on. We talked about the Westfall Act. It's there. We talked about a man working as a full-time clerk. We already went over that. No one's followed up with me about having questions about that one, so I'm not going to spend time there. Here's another one. A worker at a chemical factory started a fire when she negligently disregarded a lit cigarette that she had been smoking. Which of the following facts, if true, would best support a finding that the chemical factory should not be vicariously liable for the worker's tort under a theory of respondeat superior? We've got a worker, right? We've got a negligent act, discarding a cigarette, right? We've got a fire that's caused some injury or property damage, right? Under respondeat superior, which is a type of vicarious liability, right? What is going to help? Which of the following facts, if true, would best support a finding that the chemical factory should not be? Remember, I told you there's very, 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 very few times where the employer is not going to be responsible if the employee is acting within the scope or incidental to the scope, is negligent, and causes damage or an injury. Here's my options. Chemical factory had a strict policy. What did we talk about being analogous to strict liability? That doesn't get me off. As the employer, doesn't get me off. State law made it illegal to smoke. State law, I like it. What did I talk about? Strict liability doesn't get me off. The worker was smoking a cigarette while on a scheduled break, B-R-E-A-K, away. Worker was a receptionist whose job's duties did not involve interacting with the chemicals. Best answer, C. That doesn't make sense. Come see me, right? Now, moving to new information. Vicarious liability for vehicle owners did not cover this on Monday. Vicarious liability for vehicle owners. You are responsible for this. That's why we're going to go over it. Here we go. To increase the likelihood that people who are injured by the use and operation of automobiles, right? We want to make the plaintiff whole, right? The person who was injured at no fault of their own, we as a society want to make that person whole. Because we want to make them whole, we've created this doctrine of law that says if an innocent party, or it doesn't have to be innocent, right? Because it depends on if you're in a contributory negligence jurisdiction or comparative negligence jurisdiction, but let's just keep this simple. If you are injured as a result of the negligence of how the defendant was driving or operating the vehicle, you're injured as the result of the driving or the operation of a vehicle, you as the injured party have a right to sue the owner of the vehicle. This isn't a worker-workee situation. This isn't an employer-employee situation, but it is still vicarious liability because you're holding one person who had nothing to do with the negligence liable for the negligence of someone else. Why does that make sense? Well, you might be the kind of person who lets everybody drive your car. And it only takes one of the everybody who's driving your car to get into a wreck. Who's going to get sued? The everybody who's borrowing your car? Well, in many instances, if I've got to borrow your car, I don't have a lot, right? In terms of deep pockets. Who's going to have the deep pocket? The person who owns the car. I understand that the term deep pocket is relative, but why would that person have deeper pockets than the one who's borrowing the car? Because it is the owner's legal responsibility to what? Have insurance. So I want to be able to sue the person who has insurance, because 9 times out of 10, the insurance is going to pay the injured party. Got it? All right. Let's do Levitt. I will grade Levitt. I will return Levitt, but we're getting ready to go through Levitt. If you have questions about Levitt, once you get them back, let's not do that at class time. We've got 45 minutes. Let's not do that at class time because we're going through it together now. You will have the PowerPoint to refer back to it. You can use the PowerPoint to compare whatever it is you wrote to whatever it is we suggest here, right? And if you do that comparison, you do that reflection, you do that analysis, and you still can't figure out why you missed something, let's have that conversation. But we are building our skills of self-actualization. We are building our skills of self-accountability. We are building our skills to be lifelong learners. We are building our skills to be independent and to be accountable, right? I'm giving you, quote unquote, the key, K-E-Y, answer, so that you can compare that against what you've written, right? And see if you can diagnose what you may have missed, what you may have not understood, what you may have overlooked, where the gaps might be. And that's how we grow, right? So let's look at the Levitt case. Real simple. Plaintiff, injured, blinded in the eye. Defendant Eugene is the owner of the car, but Eugene isn't present. Eugene isn't driving the car. Eugene isn't the passenger of the car. Eugene is nowhere, he's not there. Okay. Defendant Patrick had permission to use Eugene's car. So Patrick is using Eugene's car. Defendant D. Benedetto is a passenger. The passenger, D. Benedetto, was the one chunking eggs out of the car. Okay. D. Benedetto, throwing eggs out of the car, hits a plaintiff, puts his eye out, literally. Key facts. Pedestrian plaintiff was blinded in one eye. Plaintiff's injury was the result of being hit in the eye by an egg thrown at him. The egg was thrown by defendant 3. Defendant 3 was a passenger in a moving vehicle. The moving vehicle was driven by defendant 2 with the permission of defendant 1, who owns the vehicle, but who is not present. Got it? Got it. The rule, not the rule that we walk away with, but the rule that the plaintiff sued on, the rule as the law stood when the lawsuit was filed. The law said an owner, this is statute 388, owner of a vehicle used or operated in that state shall be liable and responsible for the death or injuries to a person or property resulting from the negligence in the use or operation of that vehicle by any person using or operating the vehicle with the permission of the owner, expressed or implied. That is the state law that we find as we go into this case. So that is not new. That is the state law that the plaintiff used as the basis of their lawsuit. Plaintiff, who's now missing an eye, says, under statute 388, I can sue the owner. And the owner shall be, this isn't discretionary, the owner shall be liable for any death or injuries that result from the negligence that arose out of the use or the operation of their vehicle. They own it. Even if they're not driving it, as long as the person who's operating it had the permission of the owner. Slam dunk case, right? We done? We can move on? We don't have anything else to discuss? Not quite. Okay. Hold on, watch. I'm changing slides, going back. This is the statutory language that we find when we begin this case. This is the law that is in place at the time. What's the problem with the law? What's the problem with all laws? Every single one of them. We see the words on the page. These aren't complicated words. These are really simple words, right? This is not legalese. There's no terms of art or trickery here. This is pretty plain language. Yeah? What's the problem? What's the problem? What's the problem? We're going to get to the issue in just a second. We're going to get to the issue in just 1 second. So, taking the law, I highlighted. The statute that exists at the time of the EYE outage is owner liable, even if absent, if there's a death or injury that results from the operator's negligence. That's the operator of the car, their negligence. The negligence arose from the use or operation of the vehicle. And the operator had the owner's permission to use and operate the vehicle. I ask you again, what's the problem? Boom. This is an example I told you at the very beginning. I really would love for you to practice the 2 formats of legal writing when it comes to legal briefs. And for writing appellate briefs, there's 2 generally accepted forms, the under does when form and the whether when form. I said, I want you to practice it, right? Because when you get into appellate litigation and some of your 2L classes, you're going to be expected to show this skill. But I also said, if you just want to get to the nitty gritty of what the case is, I can take points off. But I'm going to take points off if you give me an under, a does, and not a win. I'm going to take points off if you give me a whether and not a win, right? Because you're trying to use the formula, but you're not using the whole formula. If you want to say, I don't care about the formula right now, I will make sure that I'm issue spotting. Here's one way to do it. There's no whether when, there's no under does when. Here's the issue. What the heck does arising out of the use or operation mean? What does that mean? What does that mean? I'm going to go back a slide. Here's the rule as we find it. This is not the new rule, right? The new rule is going to answer the question that's presented by the issue. This is the old rule. This is what we start this case with. This is what the trial court is looking at when they see this case. Owner liable, even if absent, for the death or injury, if the death or injury results from or arises out of the use or operation of the vehicle when someone who's driving the vehicle, who's not the owner, has the owner's permission. That's really pretty straightforward, right? Except for, what the heck does arose from the use or operation mean? That's the question that we're trying to ask. That is the question of our inquiry. That is the question of the appellate court. That is the issue. If you got an issue other than that, then let's have a conversation. If you don't understand how we got this issue, then let's have a conversation. Let's not have it in class because there's just not enough time. Come and see me. Text me, call me, email me. Let's set up some Zoom time. Your responsibility is to be accountable for what you learn and what you don't learn. If you get out of any class not having learned something, that's on you. It's not on the prof. It's on you. Okay? If you don't understand how we came up with this question as the question to be answered, the question that is dispositive, but for this being a question, we wouldn't have a case. If you didn't come up with that, let's talk about it, not in the very small 45 minutes that we have to cover materials. For those who get it, we got to cover some materials. If you're not understanding it, come and see me. That's your rightful duty. Okay, here we go. Plaintiff's argument. Trial court, using the law as it was written. Basically, plaintiff saying, you got a slam dunk case. The law as is currently written says that owner is liable if the owner gives permission to a driver and the driver uses or operates that vehicle in such a way that another is injured. Using the vehicle to carry a passenger who's launching eggs at innocent bystanders. The speed of the vehicle, the momentum of the vehicle, the velocity of the throw, et cetera, et cetera, et cetera. We get really deep into the physics here. That equals that little egg hitting my eye with such a force that it put my eye out. I need you to compensate me. Oh. And I don't think you're going to be able to give me another eye unless I'm Steve Austin, $6 million man. Right? So, short of being able to give me a bionic eye, make me whole. Here we go. Let's not go there. Well, no. Yeah, I guess we do go there quickly. Here we go. All right. We get to the rule of law that I expect to see on your briefs. How do we get there? There's a lot of conversation about what does arise out of the use or operation of the vehicle mean. The court starts reviewing a whole bunch of cases. The court gives the law clerk, says, research this for me, write me a brief. The law clerk comes back with a brief with all these different cases. We've got a line of cases out of California and a line of cases that believe with the cases out of California that says, yep, here's a problem. The car was used and operated in a way that allowed this tortfeasor to behave negligently. Ergo, tortfeasor's liability should be given to the owner of the vehicle and let the insurance companies work it out. Yeah. Further research, did the law clerk stop there? Of course not, because that's not the law clerk's job. The law clerk is writing a memo. So the law clerk is asked to find the law, right? What is the status of the law? So in continuing the research, the law clerk finds, oh, wait, hold on a second. There's also a series of cases, Golan being one, out of New York that says, oh, Scott, that's not what's going on. You've got to look deeper into the use and the operation, right? Just because the car is involved, you can't jump to this substantial factor kind of testing of the proximate causation, right? You've got to really take a step back and you've got to really look at what does arose from the use or operation of the vehicle really mean, right? You may have had to read this 6 or 7 times, 7 or 8 times, doesn't matter. However many times, your job is to get to the bottom. The court explains that based upon the Golan series of cases out of New York, arising from the use and operation of a motor vehicle means this: injury must have arisen out of the inherent nature of the automobile. Okay, explain that same thing to me, but explain it to me differently. No problem. The injury has to arise out of the inherent nature of the territorial limits of an automobile and the actual use of the automobile. Okay, I think I understand that better than the first example that you gave me, but can you explain it to me? Same thing again, differently. Sure. The automobile has to play more of a role than simply contributing to the cause and the condition. Okay, I think I understand that, but can you say it to me differently? Sure. Bill has to be an instrument, has to play a major role in the injury, has to be doing something other than transporting the fool who acts negligently. How about that? Right? Why? Legal cause, proximate causation. We are intimately aware of proximate cause, right? Right? We know we're looking at foreseeability, right? We're looking at intervening causes. Oh, hold on just one second. Hold on just one second. We know that if we're looking at intervening causes, we must be looking at superseding causes. Ding, ding, ding. You got another winner. Got another winner. So what does Levitt announce as its rule? Here it is. This is what you should have written in your brief. The rule of Levitt Levitt gives us this rule. Liability on the owner occurs when? One, there's a death or an injury to the person or the property. Two, the death or injury is the result of the operator's negligence. Three, the negligence arose from the user's use or operation of the vehicle. Four, the operator was using the vehicle with the owner's permission. Is there another way that I can say that and still get my point? Yeah. What's the other way I can say that and still get my points? Arising from the use and operation of the motor vehicle means, because, hold on, I'm going back. Check it out. I'm going back. I'm going back to the issue statement. Go back, issue statement. What does arising out of the use or operation mean? Hold on, I'm going forward. Forward. Arising from the use and operation of the motor vehicle means, oh my goodness. Asked a question, what does this mean? And my answer, which is my rule, says this means the injury must have arisen out of the inherent nature of the automobile, the nature of the automobile. The nature of an automobile is not to act as a launching pad for a fool who's throwing eggs out of the car. That's not the nature of an automobile, right? The injury has to arise out of the inherent nature of the territorial limits of the automobile, the actual use of the automobile. And actually, it should probably be the actual intended use, right? Everybody intends to use an automobile to get from point A to point B. Yeah, that's the intended use. Nobody intends for the use to be to get from point A to point B while a fool in your car is throwing eggs or bottles out of the car while we're on the way to point A or point B. Got it? The automobile must not have merely contributed to the cause, right? And while in this case, the automobile with the physics, with the velocity, with the speed, with the force, probably made this injury worse, that's not the question. In other words, the insurance lobbyist said, forget that. We're not going to be responsible for that kind of tomfoolery. Legislature, we spent a lot of money lobbying you guys. Fancy dinners, fancy vacations. So we're getting ready to spend a chunk of change to make sure that the laws are going to be written as such. We, as the insurance company, aren't going to be having to deal with all of this tomfoolery. That's what the real answer is. That has nothing to do with law school. That has nothing to do with the questions that you're going to get on the bar exam, but that's what's really going on. Okay, that's Levitt. Got it? What was the reason for the court to rule the way that the court ruled? The vehicle must be used for the purpose for which it was designed. The vehicle must be used for the purpose in which it was designed. And you have to be able to show that the vehicle was being used for the purpose in which it was designed. It was not designed to be a launching pad, right? The court relied on the definition of use or operation as announced in the Golson case from New York. The court found that the causal relationship, we know causal relationship, actual cause, legal cause, between the use and the operation or the intended use and the operation of the vehicle, using it for its intended purpose, and the injury was insufficient. There's no link between the intended use and operation of the vehicle and the injury. Unforeseeable that you're going to have a fool chunking eggs at people out of the car. Got it? That's Levitt. This is where I would stop the presentation because we have probably gone close to 45 or 50 minutes. I'm not going to stop it. I'm going to go ahead and push through, but this would be a good place for you to stop if you wanted to have a break and then come back and let's do the negligence and review, which is what we started on Monday, but this is where we're going to pick up. So let's go 5, 4, 3, 2, 1, start. Negligence review, more specifically damages. This is a new slide because, again, after speaking with some of you, I think this visually is a better representation of the path, the process, the journey. We have 4 elements of negligence: the element of duty, the element of breach of duty, the element of causation, the element of damages. Okay, 4 elements. Let's look at the element of duty expanded. Duty is the duty of care. How do I like for you to always start when it comes to rules or explanations? Like, you start with the definition. My writing, what I am expecting is for you to be able to explain the thing that you're talking about. That's what I'm expecting when you're writing for me. In order to explain it means that there's some level of understanding of it. If you cannot explain it, then you don't understand it. So if I asked you, what is the duty of care? Explain that to me. In essence, I'm asking you to define for me what you mean by duty of care. This is what I mean. Duty of care is a legal obligation that is imposed on you, that requires you, mandates you, directs you, encourages you to use reasonable care as that is defined by a hypothetically reasonably prudent person to perform acts in a way that avoid causing injury to another person. Duty of care. It is a legal obligation to do whatever it is that I need to do in a way that is intentionally designed to avoid injury to you. Just because it is a legal obligation, does that mean that it is only born in the law? Do I have statutes that say you're supposed to do certain things? Sure. Duty of care when you're on the highway driving. What does that mean? That means that you have an obligation, legal, to use reasonable care when you're driving down the highway, using and operating your vehicle in a way that is to avoid causing injuries to somebody else, right? Reasonable care, driving on the highway. Do we have a statutory law that helps encourage you to use reasonable care? Sure, we do. It's called a speed limit, right? Speed limit is intended to encourage you to drive in a way that's going to avoid injury. That's what we're supposed to be doing. Now, that's not what a lot of us do, but that's what we're supposed to be doing. And that is a duty, an expectation, an obligation, an imposition that is put upon us by law. Got speed limit. Violate the law, speed, get a ticket, right? But there's lots of duties that are put upon us, that are expected of us, that are imposed upon us, that have nothing to do with the law. Might be a regulation, might be a policy, might be a standard operating procedure in our office. It might be a professional standard. It may be something as simple as an expected community standard, right? So just because it's a legal obligation, do not think that the only way that that obligation exists is by statute. Because remember, it's an obligation that is defined by the breadth of a hypothetically reasonably prudent person. That reasonably prudent person might have a high school education, may not. So what? Are you reasonably prudent? Doesn't mean that you got to have 25 degrees, right? The idea that the more degrees we are, the smarter we are, well, that's a lie. We know that. Right? I mean, so don't limit yourselves by saying that the duty is a legal duty imposed by law. It is a legal duty, but it can be imposed by law. It can be imposed by regulation. It can be imposed by policy. It can be imposed by professional standards, et cetera, et cetera. Causation expanded. We're not going to go through it again. We beat this horse. Actual cause, proximate cause. We've talked about it. Go back 2 slides. 4 elements. We expanded duty. We expanded causation. And now we're going to take a greater look at damages. Ready? 3 categories of tort damages. 3 categories of damages. 3 categories of damages. Economic damages, non-economic damages, punitive damages. I have to have a duty. I have to breach my duty. I have to have causation. I have to have damages. I can have economic damages, or I can have non-economic damages, or I can have punitive damages, or I can have any combination that specific jurisdiction requires. Don't forget specific jurisdiction. I might be in a jurisdiction that says you don't get anything unless you prove economic. Now, if you can prove economic, I might allow you to include non-economic, and I might allow you to include punitive, but you get nothing with non-economic. If that is what the statute says for that jurisdiction, follow that. If you get a question that says, in order to get the non-economic and the punitive, you got to have economic first, then you're going to be looking in the facts for economic damages. If there's nothing in the facts for economic damages, the rule of the question, the jurisdiction of the question, says you don't get to go to non-economic and punitive. All I'm saying is just read, right? We are inclined as a human being to try to find generalities that we can take from place to place. If this, then it must be that. So if it's that here, then it's got to be that everywhere, right? That's not how the law works. It's not how the law works, right? That's why most lawyers are hated, because most lawyers will answer many questions with, it depends. Because it depends, okay? If you're getting a question from me, I'm going to give you everything you should need as a lawyer to answer the question. And if I don't give it to you, don't help me by adding in stuff that's not there. All right, so let's get back on track. Damages, 3 categories: economic, non-economic, punitive. We're going to go to economic first. Why are we going to go to economic first? Because up until now, all we've done is economic. That's all we've done. And that's all we're going to do, right? But that's all we've done. But that's not all that exists. But that's all we've done. Economic. Damages that are intended to compensate the injured party for their loss. Damages that are actual, measurable, monetary, quantifiable. Economic damages, 1 of 3. Economic damages continued. An example of economic damages are compensatory damages. Compensatory, compensate me. Compensatory, pay me. Compensatory damages are an example of economic damages. Economic damages is 1 of 3 categories of damages. Example of compensatory damages, past and future medical wages, because those are actual. How much money did you spend on medical expenses? This amount. Oh, okay. How much time did you lose off of work? This amount. How much time, how do you get paid? By the hour. Multiply, get a number. That is actual, that is quantifiable, that is something that I can calculate. All right. Compensatory damages, these are examples. These are, go back 1 slide, 2 slides. Actual, these are measurable, these are monetary, these are quantifiable. Economic damages, example, compensatory damages, right? Economic damages, example, compensatory damages. Economic damages. An economic damage can be nominal. Say what? An economic damage can be nominal. I can have compensatory damages as an economic damage, or I can have nominal damages as an economic damage. Well, what's the nominal damage? It's defined as a small sum of money. What's considered a small sum of money? $1. What about $2? Okay, let's not do that. Let's look at the facts of the case. But in A, where we talk about billion, million, and $billion judgments as being normal as cornflakes, right? Or being as plain Jane as cornflakes. They even sell cornflakes anymore. $1 compared to millions or billions, zillions of dollars. That's pretty nominal, right? All of this stuff is relative. What have I said? 3 categories of damages: economic, non-economic, punitive. An example of economic damages is compensatory damages. Another example of economic damages is nominal damages. Yeah, got it? That's the category of economic. Number 2, non-economic damages. What are non-economic damages? If economic damages are damages that are quantifiable, if economic damages are damages that are measurable, then non-economic damages must be what? Unquantifiable, non-monetary, right? I can't count it. I can't measure it. It's not actual, right? So an example of a non-economic damage, the injury itself, emotional distress, that's real, but how do you put a dollar figure on it? Mind you, they will put a dollar figure on it, but it's not an actually calculatable number. Disfigurement, pain and suffering, those are non-economic damages. Got it? Third category damages is punitive damages. These are damages that are intended to punish. Intended to punish. They're not intended to compensate. They are intended to punish. 3 categories of damages: economic, non-economic, punitive. 2 examples of economic damages are compensatory damages and nominal damages. Got it? Yeah? Here we go. Jack and Jill are neighbors. They do not get along. Every night, Jack flashes a light in the bedroom of Jill from 10 p.m. to 4 a.m. Jill is so upset, she sues Jack for trespass to land and seeks $1. It's not a typo. Seeks $1 for the breaching of her homestead with a beam of light. Jack responds by stating that Jill cannot prove her prima facie case because she cannot prove damages. Right? She hadn't suffered any damages. She's pleading $1 as damages. How should the court rule on Jack's argument? Accept it because Jill must prove damages. Reject it because Jack is not acting intentionally. Reject it because Jill never needs to prove damages. Reject it because Jill can seek nominal damages as a means of declaring the rights between the 2 parties. D, as in David, is the answer. Economic damages can be compensatory or nominal. Why would you file a lawsuit claiming $1 as a damage? Because I want the judgment to show that I'm right, that I have a right of law. And while my damages may be nominal, the principle of me being right might be more important. Right? Answer is D for David. Got it? Questions? We're stopping there. That's all we have. That's 52 slides that we've gone through. We'll return Levitt to you on Monday. I've given you the key as how I am grading Levitt, which will be turned to you on Monday. When you come to class on Monday, you're going to put your brief in the folder that is matched, that is named empty folders, and you're going to pick up your folder from the file of folders that says return folders. I hope you guys are getting excited. Oh, and just to let you know again, it's on the slide, but Osborne, the Irwin Memorial Bank, Blood Bank, is the case that we are going to discuss on Monday, and that is the brief that you're turning in on Monday. I hope that you feel that you're making progress. I hope that this is starting to fall into place. I hope you are starting to have epiphanies of, oh my goodness, I really think that I get it. I hope that this is helpful. You know how to reach me: phone, text, email. I'm happy to sign up and schedule a Zoom meeting with you. Talk to you anytime about any of this. It is my honor and my pleasure. I hope that you have a great weekend. I'll see you bright and early Monday morning, 10 o'clock, bushy-tailed, ready to go. Thank you all again for the opportunity to serve.